Hi everybody, welcome to Law Nerds. This is our first ever video and I'm super excited. In this video we're going to be tackling contracts of employment, and this is as it relates to the Commonwealth Caribbean. Okay, so this video is going to be broken down into two. First, we're going to explain the two types of employment contracts and why it's important to differentiate the two, and then we're going to go on to tackle how you differentiate the two different types of employment contracts. But hold up. Before we get any further, I need you guys to like, subscribe, share with your friends, and drop us some comments down below letting us know what type of videos what areas of law would you like us to tackle next. Okay, so now that housekeeping is done, let's get into it. First thing we're going to tackle is why is it important to determine the employment contract. The employee versus the independent contractor. Generally, there are two kinds of employment relationships. You're either an employee under a contract of service or an independent contractor under a contract for services. Now, it's important to differentiate between the two. You have the contract of service, which is going to be an employee, and then the contract for services, which is going to be the independent contractor. It is extremely important to differentiate between the two because in most cases, the floor of employment rights is available to employees only and not to independent contractors. So you're probably asking at this point, what is the floor of employment rights? So the floor of employment rights will be stuff like holidays with pay, maternity leave, severance pay, receiving a written statement of particulars, that kind of stuff. The employer has to give those things to an employee, which is the contract of service. However, he does not have to give those things to an independent contractor, which is the contract for services. Further, it is only for the torts of an employee committed in the course of employment that the employer may be held vicariously liable. So when it comes to vicarious liability, you need to know whether the individual is an employee or an independent contractor, because you cannot have vicarious liability if it is an independent contractor. The employer at common law owes the independent contractor no duty of care, zero, none. But he does owe that duty of care to the employee. He has to take reasonable care for the employee's health, safety, and welfare at the workplace. This would come under employer's liability, and I'm going to do that in another video. Moreover, stuff like income tax, NAS contributions must be deducted from the salaries of employees, but not from the pay of an independent contractor. And there are different schedules of assessment for taxes for these two categories of labor. So it is important to know who is an employee and who is an independent contractor, because it can cost an employer a lot of money if this determination is not made. An error in classification may thus be prohibitively expensive for the employer that might find himself called upon to account for unpaid taxes or NAS contributions. It is important, therefore, that both parties be given the best advice practicable to determine who is an employee and who is an independent contractor. And I say the best advice practicable because I'm assuming those of you who are going to be watching these videos are attorneys in training who will be giving advice to the public. Your client may be an employee, your client may be an employer, your client may be an independent contractor. And you must be able to help them figure out, okay, I have an employee, I need to pay these back taxes. I have an independent contractor, those taxes don't apply. We've just discussed the importance of determining who's an independent contractor and who's an employee. Now that we have examined that, the next best thing for us to do is to go through the tests that are used to determine who's an employee and who's an independent contractor. So first we have statute, right? There are different pieces of legislation in different parts of the Caribbean that would define an employee or a worker. And then we will automatically know, well, who doesn't fall into that category is an independent contractor. We can also use designation of the parties. However, this is frowned upon a lot. And when we get into the nitty-gritty of designation of the parties, you will understand why that one doesn't really hold up in court. And the last one, you have judicial determination. So this would basically be case law, different tests that would have been settled in different cases throughout the Commonwealth Caribbean and maybe in England. And number 1 and number 3 are what you will find are mostly used. And in most cases, number 3 and number 1 intertwine, as in you will find that in newer legislation, there are pieces of the case law, and in newer cases, you find pieces of the statute. I have an ebook, which I will drop the link to below in the description box. And that ebook goes into great detail on all the cases, the statutes, everything. If you guys are interested in getting that, just check the description box below and you guys can get that ebook. So we're going to start with the statute. Now, throughout the Commonwealth Caribbean, you will find that there are that you can place statutes into 3 different categories. That's the traditional category, the different, and the unusual. In the unusual category, there's just the Barbados legislation, but you will find other legislation in the first 2 categories. Now let me go on to explain to you why we break them down into these 3 categories. Now, the traditional definition of an employee is the definition in legislation that's going to mention the word employee. So that's why we use the word traditional, because most of them are going to mention the employee. The ones that we call different, these are going to be the ones that they don't mention employee, but they talk about workers. So in the definition section, you'll find the word worker instead of employee. But you will still obviously know when they say worker, they mean the employee. Barbados now is categorized as unusual because Barbados gives a traditional definition of employee, but they go on to do something more in their schedule. And I'm going to get back to that. Let me just tackle the traditional one first. Right? So the traditional definition of who is an employee may be found in Bahamas, St. Vincent, and Dominica. And as I would have said before, these acts are deemed traditional because they mention the term employee. In St. Vincent and the Grenadines, it is going to be found in Section 4 of their Protection of Employment Act 2003. The category of statute that is deemed as different is going to be found in Trinidad, Jamaica, Guyana, and Grenada. These acts are different because, as I would have said earlier, they use the term worker instead of the term employee. In Trinidad, you're going to find this at Section 2, subsection 1 and 3 of the Industrial Relations Act. Now, in Barbados, the most unusual act in the Commonwealth Caribbean, the Bajan legislation, the legislature just had to be different. So let's get into this. Section 2 of the Act gives the traditional definition of an employee, as in it uses the term employee. However, what makes it unusual is that what is found in the first schedule of the Act, where they go on to give you factors that are to be considered in determining whether a person is an employee or not. On top of that, the Act goes on to say at the end of the first schedule, now remember the first schedule is giving you factors that you have to add to Section 2's definition. Now, after you've gone through all of those factors, it goes on to say, this list is not exhaustive and that the factors outlined are all elements in a balancing exercise to determine the nature of the contract. No one factor, therefore, is by itself conclusive, and the weight to be attached to any one of the factors is a matter of adjudication. So it's saying, yes, these are the factors, but this list is not exhaustive, and you have to look to the courts to see how much weight they're going to put on these factors. Before I go on to talk about the designation of the parties, just want to let you guys know that if you want to view the various pieces of legislation that would have been mentioned just now, you can do so in our ebook. They're all set out there. So the designation of the parties now. Basically, the courts have looked at this and said, this is where the parties may attempt to say, okay, we are operating under a contract of service, but they're actually operating under a contract for services. This approach would be more beneficial to the employer because it is easier to have an independent contractor financially than it is to have an employee. With the employee, you have to provide the flow of rights, etc., that we would have spoken about before. So the question that arises is the designation of the parties as expressed in the contract binding on the courts? That is what we really need to get into. That question is answered in these three cases. There are two cases though that I want to spend a little time on. I'm going to give a really brief breakdown of Transport and Industrial Workers Union, and then I want to go to Massey and Crown Life Assurance and just mention something that Laura Denning would have stated. So Transport and Industrial Workers, in that case it was stated, in deciding whether a contract of service exists, a court must look at the realities of the relationship. It is not necessarily bound by the label or description which the parties themselves give to the relationship. It is entitled to look at the surrounding facts and come to its own conclusion. So in Massey and Crown Life Assurance, Laura Denham would have stated that the law as I see it, the law as I see it is this: if the true relationship of the parties is that of master and servant under a contract of service, the parties cannot alter the truth of that relationship by putting a different label upon it. If they should put a different label upon it and use it as a dishonest device to deceive the revenue, I should have thought it was illegal and could not be enforced by either party, and they could not get any advantage out of it. An arrangement between two parties to put forward a dishonest description of their relationship so as to deceive the revenue will clearly be illegal and unenforceable. Let's just note that any cases that are mentioned in this video, the full breakdown of the cases are found in the ebook. So as I said before, I will just drop that link in the description box and you guys can just read through that ebook when you're ready to. Alright, on to judicial determination. Now here we're going to look to the courts and their decisions and the factors that they consider important in determining who's an employee and who's an independent contractor. Now, these four tests were brought up in the case of Sagicor and Carter et al. That was in 2007. In that case, Chief Justice Simmons showed that there were four principal tests to determine who was an independent contractor and who was an employee. The citation, let me just go back to the citation for that case. Sagicor versus Carter et al. 2007 in brackets 71 WIR 74. Alright, so now let's start with the control test. So the control test basically holds that a worker is an employee if his employer can control or has the right to control not only what the worker does, but also the manner in which he does it. In contemporary times, controlling the manner of doing work is only one indicium to which the courts will look in determining the status of a worker. It is fair to say that the control test, therefore, is no longer decisive on its own, but it still has great importance. So we're going to move on now to the organizational test, right? Because of the limitations of the control test, as revealed by changes in social and economic conditions, the courts have searched for a different test. In Chief Justice Simmons' desire to extend employee status to certain professionals, he and Lord Denning propounded a new test. Right? They came to the conclusion that it was going to be called the organizational or integration test. If the organizational or integration test is applied to determine the nature of the employment relationship, a court has to find those which point to the workers being part and parcel of the organization, or those which point to integrated work. The organizational test has not gained much ground in common law, but having said that, the tests, just like the control test, although they haven't made much ground or they can no longer be applied, they're still of relevance in some cases, but judges have developed other tests which either look to the economic or business reality of the relationship or examine the multiple terms of the contract between the parties. So with that being said, we're going to move on to the economic reality test. All right, so this test, as was said, is of business or economic reality, and it essentially asks whether the worker is in business on his own, and that obviously will be as an entrepreneur or independent contractor, or if he works for another who takes the ultimate risk or loss of chance of profit. Lord Wright recognized that in the more complex conditions of modern industry, more complicated tests have often to be applied. He suggested a four-fold test involving control, ownership of tools, chance of profit, risk of loss. The question can only be settled by examining the whole of the various elements which constitute the relationship between the parties, and that is how we get to the multi-factor test. So a contract of service exists if the following are fulfilled. 1, the servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. 2, he agrees expressly or impliedly that in the performance of that service, he will be subject to the other's control in a sufficient degree to make that other master. 3, the other provisions of the contract are consistent with it being a contract of service. So for example, a contract obliges one party to work for the other, accepting his control and to provide his own transport. Even though he has to provide his own transport, this is still a contract of service, as the obligation to provide his own transport does not affect the substance of the contract. If it affects the substance of the contract, though, it's a whole different story. All right. Now that we've looked at statute, we've looked at what the parties agree to, and we've looked at the tests that the courts look to in judicial determination, right? We must take into account that there are 2 additional factors that should be added to the 4 tests that the courts look to. And those 2 additional factors are that there must be personal and exclusive service, and there must be mutuality of obligation. So I'm going to try real quick to run through these 2 and explain them so that this video isn't too long. So this is basically as it says on the screen: personal and exclusive service. Basically, if the employee is supposed to dedicate him or herself to the job and exclusively to that job and only that job and can't work for nobody else, then they're more than likely an employee. So let me just say Huggies. If I have to dedicate myself to Huggies work and I can only work for Huggies and I can't go and work for Pampers, then more than likely I'm an employee of Huggies. If I have to give them all my services and I can't go and give Pampers any of mine, I have to be an employee of Huggies. So as I would have said before, because I don't want this video to be extremely long, I am going to go through only one case, but in the ebook we go through all the cases and we also explain what distinguishes the case of Express and Echo Publications versus Tanton and McFarden. So we distinguish these two cases in the ebook, but I want to just mention this case right now in this video. So in AutoClines Limited versus Belcher, the company had contracted with the claimants to work cleaning cars. This was a case where the workers were claiming holidays with pay. And you would know holidays with pay, you have to be an employee to get that because that's in the floor of rights. Okay, so they had to show that they were workers and that they were entitled to holidays of pay. The contracts were nil-hour contracts, which neither required nor entitled the worker to any particular hours of work. AutoClines failed on the first instance, and it was held that they were indeed workers. On appeal, Lord Clark said the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement in truth represents what was agreed, and the true agreement would often have to be made from all the circumstances of the case, of which the written agreement is wholly a part. Mutuality of obligation is the obligation of an employee to provide work and pay for it, and an obligation of the employee to personally perform it. Where the employer has work to be done, the employer would be under an obligation to call on the employee to do it. And the mutuality of obligation comes in that the employee will be under an obligation to come and do it. So the employer is obligated to provide work, to provide pay. The employee is obligated to perform the work. Okay. Unless you have the mutuality of obligation, the courts will not state there's a contract of service. If you are free to turn up when you please as an employee, then you are under no contractual obligation to the employer. So basically, no mutuality of obligation equals the presumption by the courts that you are an independent contractor. So that we can save time again, I am just going to place these cases here. I guess you guys can write them down. You can go and search them on your own, but all four cases are explained and case briefs are given of all four cases in our ebook, which, as I said before, I'm going to drop the link to that in the description box below. But these four cases are really important when it comes to mutuality of obligation, and I really think that you guys should give them a read. So we've come to the end of our very first video, and I really hope it was helpful. I really hope it helped you guys. I hope it was easy to understand and easy to follow. If you have any questions at this point, you can feel free to drop them in the comment section. I will try my best to respond to all questions. But yeah, see you guys again on our next video.